SJC-13305, Commonwealth v. John v. Monteiro.
Okay, Attorney Burbine, whenever you're ready.
May it please the Court, Carolyn Burbine for the Commonwealth. The question here is whether counsel has a conflict of interest, and was the Commonwealth's motion to disqualify erroneously denied. And we have a very unusual situation here where we have...
Counsel, I'm going to go ahead and interrupt you because this is a big deal. Taking a look at the position of the Commonwealth and going through Judge Sullivan's decision, the Commonwealth hasn't any evidence that the defense will be antagonistic here with Mr. Barrows and Mr. Monteiro. That's a specific finding that Judge Sullivan makes, that at oral argument, there was no indication that Barrows is anything to do with the murder. The way that Attorney Scarpiccio indicated she was planning to pursue the motion for a new trial did not effectively have to say Mr. Barrows did it. And so particularly with the waivers that were signed by both men, how did Judge Sullivan abuse his discretion here? How did he make a clear error of law here?
Well, it's our position that when you look at the rules of professional conduct, and you look at Rule 1.7, counsel has a concurrent conflict of interest if a representative of one client is directly adverse to the other.
That's the point. That Judge Sullivan found that it's not.
Well, I disagree because I think that to really figure out if there's a conflict of interest here, we have to look at what does the defendant have to prove? What does the defendant have to prove at this hearing on the motion for new trial on ineffective assistance? So the claim of ineffective assistance is that the lawyer, trial counsel for Barrows, for Monteiro, didn't investigate if Barrows was the shooter, didn't sufficiently investigate it, neither did the police. And I think the focus here has always been on just prong one. But the Commonwealth, has to also think about prong two. So the defendant's going to have the burden to show prejudice from the failure to investigate Barrows. So what is the Commonwealth going to have to do to counter that? And the only way we're going to be able to disprove the defendant's theory that he was prejudiced by the ineffective assistance is to show what we would have done at trial had that been raised. And we have to show that it wouldn't have amounted to anything because Barrows didn't commit the crime. And how are we going to do this? There's a possibility that at this motion hearing, we may call Barrows. And then you have opened the door to all of this. We call him. Someone's going to have to advise him on the 5th. Given the attorney's position representing Barrows Monteiro, what is that going to be like? And let's just say, theoretically, he takes the stand and he says, I didn't do it. How can counsel cross-examine him at this juncture? She's representing both Monteiro and Barrows, and now Barrows has said I didn't do it, which is counter to Monteiro's position in this motion. So,
but it's not counter. It's not counter because Judge Sullivan found that in order to be successful on the motion, he didn't have to say that Barrows did it.
You don't have to say that Barrows did it, but she's still pursuing. She's still pursuing information through this motion for new trial hearing to point to Barrows. That's the whole point. Like, how can counsel have been ineffective in failing to investigate this if there wasn't something there? So she's pursuing attack where she's trying to gather information to show that, Barrows should be implicated and that counsel failed to understand that, failed to pursue that. And now, should she be successful, the police are going to be looking at Barros again. New defense counsel from Monteiro is going to be looking at Barros again. And there are ties to Barros in this record, or if there weren't, then defense counsel would not have been able to even get an evidentiary hearing on this. So there was some evidence that Monteiro and Barros were known associates with another man, with one another and with Leverone. This man, Leverone, told the police that a man named Gonzalez drove both Monteiro and Barros to the victim's house to kill them. And there was evidence that Monteiro sold the gun with blood with one of the victims in the barrel to an FBI informant. So there is a chance that Barros could be implicated. So even though the focus has been on prong one, I think when you look at prong two, we have a real possibility of a problem at the motion for new trial hearing. What do we do if in the middle there's an ability to elicit evidence against Barros in a way that, this conflict comes to a head? What happens if Barros gets on the stand and says, I didn't do it? How can counsel cross-examine him? And then what happens with that evidence? It wouldn't be fair to the Commonwealth, in my view, to suppress it. What's the answer? And I think that's a real danger that has to be addressed now.
That's the prong of the doctrine that I want to get at. It has to be addressed now. I'm looking at prong one of Fontenez, and whether or not it was an abuse of discretion for the single justice, where there's very significant discretion as to whether or not to get to the merits. Is this an extraordinary circumstance that requires the single justice to get to the merits? And when you answer that question, I'd ask you to take into account all the contingencies that you just listed to answer Justice George's questions.
Well, I believe that it is, because I haven't seen any case law with this scenario. Usually it's defense, counsel represents both the defendant and a prosecution witness, or you have counsel representing a number of co-defendants. I didn't see anything out there on a post-conviction motion where counsel's alleging ineffective assistance against another client. And, it doesn't have to be a deliberate act by counsel to fail to recognize this. I mean, the most well-meaning counsel can make this error. It's so unusual. But I do think, yes, I'm sorry, but
That's okay, but
right,
hold on. Let's say you're right about that these contingencies could happen.
Right.
Waivers might not be good. Maybe there wasn't a full colloquy, conflict colloquy, and all the things that you laid out, and then maybe on the second part of, it's not really Safarian, but second part, that might implicate in some way Barros if he testifies in cross-examination. All the contingencies you laid out in response to Justice George's questions. That doesn't mean that the single justice has to determine under general superintendence that he needs to reach the merits, that this is an extraordinary circumstance. And indeed, I'm wondering about all the ways you had to weave through your answer to get to Justice George's question about how you deal with Judge Sullivan's findings, whether or not the issue would even really come to a head.
well, I think it's an extraordinary circumstance, and we didn't have any other avenue of relief. And I think,
It's not dispositive, and
No, it's not.
And you didn't file a 221. That whether or not this is an interlocutory order, you're supposed to go through that step, right?
I don't believe so. I thought we did it correctly doing the 211-3.
I know, but when you lost the 211.
And we lost the 211-3. I think we petitioned the court for permission to appeal, and it was granted. I believe that was the avenue. But I just feel like this is such an unusual circumstance that the profession needs an answer. I mean, the profession polices itself. We're responsible for, prosecutors are responsible for pointing things like this out. We don't want to be in a position for the good of the profession where we find ourselves in the middle of a hearing and no one knows what to do about it. And I think it's that important
Oh,
an
that's not
issue.
necessarily true, because if there were, there are instances where conflicts and questions about people's potential exposures happen all the time, and the court could appoint somebody for Attorney Barrows that's independent of Attorney Scarpiccio. We do that in Martin hearings all the time for witnesses when they say there might be a fifth. That happens in real time. But the whole point is, I guess, if you go through the progression, the single justice is looking at what happened below and looking at the opinion of Justice Sullivan and saying, is this one of these things, back to Justice Lowy's point, that I should involve the court in at this point, and the idea that it hasn't met the 211.3 threshold. Again, you got two levels of, you got abuse of discretion by the single justice, and I'm just wondering, just because you don't think that there's an answer out there, does that meet that standard?
Well, I mean, we're talking about two gentlemen who have been convicted of murder, and Monteiro was convicted of a double murder. And I think that the stakes are so high. This isn't a trespass case. We really don't want to be in this situation. And I think everyone would look for guidance on this. And I think that the judge did abuse his discretion looking at the rules of professional conduct, looking at the case law. We disagree with his conclusion, and I think you have to also, just based on everything I said in my brief, but also I think that, where we're a profession that polices itself, and we really need to know the answer to this question. I don't think it's impossible that it would arise again, and it's unusual enough.
This is the kind of thing that a client can't assent to?
Yes, I do. And even if the court disagrees with me, I still think that at least there should have been some kind of colloquy, a more thorough colloquy with, I know Barros had one, Monteiro never did. I know they signed the waiver, but I mean, counsel who is advising them on the waiver knows information from both individuals. And while she may not realize it, it may be coloring how she's advising them. And so I think that, it's so important to the profession. We police ourselves, we police each other, that this be addressed. And I don't think it could be waived, at least not without a sufficient colloquy of each individual by the judge, at the very least.
Before you go, can I just ask you to respond, maybe in a 16L letter, to the defense request for attorney's fees?
Yes, Your Honor.
Okay, great.
Does the court have any more questions? Thank you very much.
Thank you. Okay, Attorney Musfarrer.
Good afternoon, Your Honors. May it please the court, Eduardo Masfera and Daniel Fullerton from Mactel on behalf of the appellee. The court should affirm the order of the single justice and the trial court, as there is presently no concurrent conflict of interest, much less an unwaivable conflict of interest, and the trial judge properly exercised his discretion in denying the Commonwealth's motion.
Can you start on prong one of Fontanez as to whether or not this is extraordinary circumstances and whether or not there's a remedy?
It's not extraordinary circumstances. We have issues. There's ample case law about whether or not there can be a waivable conflict and the procedure to go into. The procedure was followed in this case. Waivers were filed with the court.
And if the Commonwealth loses the motion for new trial,
Yes.
is there an appeal?
On behalf of the Commonwealth?
Yeah.
I suppose they will file an appeal.
So couldn't it be addressed that way?
It certainly could.
I mean, that might not do it because the violation might have already happened, and this might be a present execution situation. But there's a lot going on here about whether or not this is extraordinary circumstances.
It doesn't-
And the single justice had to reach the merits.
It doesn't appear to be extraordinary circumstances. We can conduct the hearing. We can have the hearing. I know the Commonwealth poses a hypothetical. What about if Mr. Barros is going to do something? There has been multiple hearings scheduled. The Commonwealth has established its witness list. It has not called Mr. Barros as a witness.
Well, isn't that in part because things haven't started yet?
No, Your Honor, it was supposed to start on various occasions, and every single
Yeah,
time.
we aren't, there was never a position where the attorney was starting to do things that would implicate Barrios, right?
So
That hasn't happened in a trial yet.
it's a motion, for the motion hearing hasn't started because the Commonwealth has sought continuances. So in other words, we could have started it, there's been no
But
stay.
even so, the point is that whether you can, let's take a hypothetical situation then. Until you're actually in front of the judge in a hearing, whether it's a motion for new trial or a first-degree murder case, this issue won't be fully fleshed out until that moment. Is that right?
No,
No, why not?
because the Commonwealth hasn't announced an intent to call Mr. Barros.
But,
So they would have to put him on a witness list ahead of time. So before the hearing even
but
starts.
what if the hypothetical witness or person who they're going to say is the culprit in this rather than the defendant?
That's not the point of the motion, but yes.
I understand, I understand. Until so if they put him on the witness list, would that change anything?
Is Mr. Barros going to testify? Is he going to waive a Fifth Amendment
Is he
right?
possibly going to testify?
There'd be no logical reason why the person who this prosecutor's office has convicted of murder would then turn around and decide to assist them, separate from anything else, separate from the potential conflict of representation. There's
Right.
no realistic thought that they would come in
But
and do
he
that.
might turn around and assist Mr. Monteiro.
Well, again, there's no indication that that is going to occur. He's not on Mr. Monteiro's witness list. The issue about Mr. Barros is picking one issue out of a 100-page motion for new trial, right? Mr. Barros as a third-party culprit isn't even the main issue of the motion for new trial. He's not even the main third-party culprit. Mr. Lebron is the person who the vast majority of Mr. Monteiro's motion for new trial points to as someone who is likely to be the third-party culprit. He points to a variety of errors that trial counsel made. They then spend, I think it's 10 pages of the record, the impounded record appendix, going through the potential misconduct that the Brockton Police and potentially the Plymouth County District Attorney's Office has been conducting over a series of murder trials. Those are the main issues of this case. The Commonwealth picks one that Mr. Barros should have been explored as a third-party culprit in order to avoid everything else that's happening in this motion.
Attorney Masferri,
Yes, Your Honor.
going back to Justice Lowy's point about Fontenez, which is the problem that I have, is would it be a different procedural posture if, in marrying Justice Seifer's question, if the hearing had begun and in the unlikely event that Mr. Barros decides to testify, that at some point the questioning from Attorney Scarpiccio might then implicate the conflict, and perhaps then you could stop it and then say, now we have an issue we may not be able to resolve, and maybe now this might be properly a subject of a 211-3, perhaps.
It could have been, or Judge Sullivan could have stopped the proceeding and reported the question.
Right.
Right? But we don't deal, in my experience, this court doesn't deal with hypotheticals when deciding whether you've reached an extraordinary point that you need to stop everything and have this court weigh in. We are
No, but
not
we
there.
do get concerned if there's an actual conflict, and we might end up with a first-degree murder case that has to be retried, don't we? I mean, I would be concerned, but.
But again, we've sort of jumped a few steps there, Your Honor. So for
Right.
example, if Barros is called and he doesn't assert a fifth and he does testify, if all those things happen, then maybe we do need to stop the proceeding and do something else. But we are not there. We have stopped this proceeding for 2 years based on a maybe. Maybe there could be a potential conflict if, right, everything lines up in a particular way, and now there's an actual direct conflict because the witness on the stand is represented both by the lawyer who's also representing someone. That might, I would agree with the court, that could present an actual conflict that has to be resolved.
Stands right now, under our case law, putting aside that there was no 221 filing, The single justice in this context doesn't have to find there are extraordinary circumstances that require general superintendents, because we keep on talking about all the different ways you have to get to the situation where, yes, maybe it would be. That would be an interesting case.
It would be, but we are not there. And in terms of the need to do it, as I'm sure the court has already realized, the motion was filed in August of 2020. The Commonwealth didn't realize that it needed to decide to raise this issue until the eve of the hearing in 2022. Sorry, 2021, I apologize. Which is concerning. In other words, the issue was raised back in 2020. Mr. Barros did a colloquy with the court. Waivers were filed. The Commonwealth made no objection to that waiver, no objection to that process. They didn't say this wasn't enough. They didn't say we needed to do more. They didn't say anything else needed to happen. It was done. And then on the eve of the hearing, they now start raising, oh no, this is an important, crucial issue we need to discuss, which is unfair because there isn't an actual conflict. As Judge Sullivan questioned the Commonwealth, right, is there evidence that Barros is literally the person who committed the crime? Does the Commonwealth have some evidence of that fact? And the Commonwealth conceded there is none. So raising a third-party culprit is not the same thing as saying or proving the third party did it. We're looking at only the evidence the trial counsel had at the time and asking, did he perform his duty to explore the third-party culprit and present that to the court? And the answer that we are arguing is that he did not. There's significantly more evidence about other errors in the trial, but that certainly is one part of it. But we are not, that is not an issue that is ripe at this point to have stopped the process for 2 years, not started the hearing, and have Mr. Monteiro in jail for 2 years waiting for his hearing. That is not what we are here presumably to do. And a further concern of that is, where is the limits of the Commonwealth's ability to disqualify counsel? Certainly, it makes, on some level, it is arguably ethical and a pursuit of the government, of the Commonwealth, to ensure that the defendant has a fair right to counsel. They raise the issue with Judge Sullivan, he examines it, he denies it. That seems reasonable. But then to continue to do what they've done here, stop the trial, seek stays, go to the single justice. When the single justice denies the stay, not doing the proper course to appeal his decision, but rather going around him to file an emergency motion to stay before this court in order to get the stay that they couldn't get from the single justice, that's not making sure that that lawyers are self-policing properly. That's not a fair use, from our perspective, of the Commonwealth's interest in this case. Its interest was decided when Judge Sullivan said there was no conflict. There was nothing else for them to worry about doing, especially since, as Your Honor Saval noted, nothing else happened to demonstrate an actual conflict. And so it seems that the Commonwealth's interest beyond that point is simply to stop the trial, simply to stop the motion, to not go forward on it, to not conduct a hearing that would involve police officers, prosecutors from that office, as well as former defense counsel, who they have taken extraordinary efforts to get back into the Commonwealth, since he doesn't live here anymore, in order to do the hearing. That continuously has been delayed because of the Commonwealth. Even after this court denied the stay, the Commonwealth picked a date. That prosecutor resigned from the office. It was assigned to the head of the murder unit. On the scheduled hearing date, they reassigned it to someone else who joined the office, and it has been rescheduled again. So that's why it's not being heard until July. More delays because the Commonwealth keeps changing who they want, and I appreciate people leave the office, that's a fair reason, but it's been changed twice since then. And so from our perspective, Your Honors, there is no current, present conflict that warrants this court's involvement in the case, and it's certainly any potential conflict is waivable and has properly been waived. For all these reasons, we ask the court to affirm the decision of the single justice.